So, before you go through this video, what's it that is stopping you to do whatever you like, wherever you want to go? What's it that is guiding your behavior and regulating the whole society? What lets you walk around without fear? What makes you sleep soundly at night? What's it? You probably will say it's law. Then I have another question for you. Yeah, what's law? Rules, regulations made by government, constitution, medium for justice, guide to societal order.
So now we are going to explain you about law and the various definitions of law. Myself, Rutuja Sakharkar.
I'm Rutuja Mandhare.
I'm Singh Rana.
And I am Mukul Sharma. So, first I would like to explain you the term law. The term law was derived from the Old English word lege. The lege denotes the kind of rules and the principles which regulates the human behavior. It is very difficult to define the term law. Many jurists attempts to define the term law. So we got many views and the definitions regarding this topic. So for the purpose of clarity, we are going to classify the views in the different categories, and the categories are as follows. So the categories are idealistic definition, positivist definition, historicist definition, and the socialist definition. So first, I would like to start with the idealistic definition. In idealistic definition, there was many viewers who explained its definition. So one of the famous idealist, Salmon, uh, explained that the law is made defined as the body of principle and recognized and applied by the state in the administration of the justice. And the another idealist who defined this law was John Crippman Gray. John Crippman Gray was a jurist. He stated that the law is the state or any organization of the body is composed of rules which is characterized or the works under the court. That is, the judicial organ of the body lays down for the determination of the legal rights and the duties. So now I'm going to talk on the positivist definition. Positivist definition, there were many positivists who viewed about the law. The famous positivist Houston, yes, the famous positivist, he said that the law is the command or the sovereignty to backed by the section. Now, the another positivist, the H.L.A. Hart, said that the law is a combination of primary rules and the obligations, and he stated that the secondary rules of the recognition of the society makes the proper judicial. Now, another view was socialist definition. In the socialist definition, the great socialist and the social viewer Dean Rosette Pound, tried to define this term law. He said the law is a social institute to satisfy the social wants. He also said the law is the social engineering, which means that the law is an instrument to balance between the society and completing the different opinions. Now, I'm going to explain you the view of historical. The historical definition was defined in many views. One of the historian who explained this term was Sowerning. Sowerning defined that law is not the product of direct allegation. He said that the allegations might be due to the silent growth of customs and the outcomes of the public. The he also state that the he also state that the profession might be opinion of the society. According to him, it means that the law is covered under the opinion of the society, because the society has to work with the uh, with the so now I would like to know views of my friend Vurtuja.
Thank you. So I am going to discuss about law in the legal and in the scientific sense. So, firstly, the word law. It was used by Roman writers to indicate rules for human activities and also to indicate natural phenomena. Legal laws, or law in the legal sense. Legal laws are created through social or governmental institutions. Legal norms determine the rights and duties of individuals. These norms are mandatory for everyone. They are obligatory and have certain ends. Judicial no- Juridical norms do not express what is present in reality but what it should be. They are established artificially and are enforced by human will. Legal laws may change or even disappear after certain time. They may vary between different countries. Some of the basic enacted laws are liberty, equality, and fraternity. Laws can be divided into two categories: public laws and private laws. So, public laws contains constitutional law, administrative law, and criminal law, and private laws contains contracts, property, torts or delicts, commercial law. So now I am going to discuss about law in the legal scientific sense. Scientific laws are statements based on repeated experiments or observations. Law in the scientific sense is a general formula that expresses uniformity. It expresses the reality and the thing that actually exists. It does not depend on anyone's will. They cannot be broken. They are produced according to the legal or logical connections. Generally, the scientific law or formula or phenomena cannot be replaced by any other formula. Edward Hartmann says that laws are not beings which dwell in the air, but only abstractions for forces and substances. It means that the law of nature are the fixed actions. Whether man knows the scientific laws or not, they still exist. They do not change with time or place. They are the equal everywhere. The term law is used in almost every field of natural science: physics, chemistry, astronomy, geoscience, biology, etc. Now I wish Rutuja Mandhare to express her views on this topic.
Thank you, Rutuja. My topic is the relationship between law and morality. Law and morality are two different concepts, but there is a unique relationship between them. Law is a set of rules which is enforced and created by the government or the authority, while morals are the rules which are enforced by the society in which we live. Morals are not mandatory. If a person doesn't want to follow it, he can break it. He can break it. But in the other side, law is mandatory. If a person doesn't follow it, he will be punished according to his deeds, and the law changes as circumstances. There are three theories which deals with the relationship between law and morality. The first theory is harm to others. It was given by John Stuart Mill in 1859. The theory states that the power or the government has the right to intervene in any citizen's life against his will, only to protect or to harm others. The second law is called as the moralistic way. It was given by Lord Delvin in between 1960s and 1950. The law states that the law the morality can use law as the same way to as it uses law to safeguard its essential things, uh, and to make decision about what is wrong and what is right. The third law is known as the paternalistic law. It is given by Professor Hart, and it is one of the most modern law in the relationship between law and morality. This law states that the government has only the right to interfere in the personal lives of citizens to prevent harm to others and harm to oneself. As there are many strong points between the relationship of law and morality, there are also some weak points. The main weak point is, if the law neglects morality, then it results that the law permits immoral actions, and which gives liberty to the person to pass the bounds which the law and the society sets. So now I would like to uh, ask Seja Singh Rana about her views on this topic.
My topic is juridical norms and the moral norms. Moral norms are the rules of the morality that people ought to follow. Moral norms are the set of the beliefs. Law and morality are intimately related to each other. Law are generally based on the moral principle of the society and both regulate the conduct of the individual in the society. Morals are concerned with the principles of the right and the wrong behavior. Morality can be a body of the standards or principles derived from a code of the conduct from a particular philosophy and the culture. Now, juridical norms. A legal norm is a binding rule or the principle or a norm, the organization of the sovereign power promulgate and enforce in order to regulate the social relations. It determines the rights and the duties of the individuals who are the subjects of the legal relations within the governing jurisdiction at the given point in the time. There are the two categories of the juridical norms. First is normativity. It regulates the conduct of the people, and second is generality. It is the binding on an indefinite number of the people and the cases. Thank you.
So now I think we make you better understand this whole topic and the definition and the views regarding the law. So thank you for listening and I hope you understand.